Hello, this is Erick Widman from Passage Immigration Law. Thanks for joining us for our live Q&A that we offer on a weekly basis. And we have some good questions as usual about the tricky and distressing US immigration system. So the first question is about something called a provisional waiver. And it's the I-601A waiver. And the question is, how long is the I-601A waiver taking? For background, to make this useful to people who don't immediately know what the I-601A is, the quick background overview is that if someone entered the US and has unlawful presence, they have to take care of that in order to become admissible and get a green card. So how do you deal with unlawful presence if leaving the US is going to trigger a 3-year bar or 10-year bar? Because if you've overstayed your immigration status by 6 months, you'll have a 3-year bar upon leaving. If you've overstayed by over a year, you'll get hit with a 10-year bar. So back in the Obama administration, they created a provisional waiver, I-601A, unlawful presence provisional waiver, which says you can apply for a waiver without leaving the United States if you have a petitioner and you have a qualifying relative. Because in the past, people wouldn't want to leave the United States because if the waiver doesn't get approved and they're hit with this long-term bar, they won't be able to come back in to the United States. So it was a reasonable, smart step to do a partial reform of the immigration system to allow the I-601A waiver to be filed here in the United States. And then if you're undocumented, you would not leave the US unless the waiver was approved. So how long is this taking? The best way to answer that is to first look at how long it's taking if you don't need a waiver and then add the waiver on. So if you don't need a waiver and you're just going to do an immigrant visa for a family member, it's about 12 to 14 months. The waiver can often take 5, 6, 7, 8 months in addition to that. So you could be looking at least 1.5 years to a full year to get the unlawful presence waiver, the provisional waiver approved, and head overseas or go to Ciudad Juarez. And that's where you're going to have your case adjudicated and you're going to get your immigrant visa interview set up, and hopefully it all gets approved after 1.5 years to 2 years of work. Because on average, our clients, it's taking 5, 6, 7 months for an I-130 petition to get approved. That's the key first step in this unlawful presence waiver process, because you cannot file the 601A waiver until you have the I-130 petition approved. By the way, the I-601A waiver can be used in situations where you have an employer who is willing to file an I-140 for you, or the diversity visa. That's another option. And finally, VAWA self-petitioners can also use their I-360 to get this first step taken care of, the petition. But then you need a qualifying relative to be essentially the sponsor, the one who shows a family member that she or he will experience extreme hardship if you have to leave the US. So in addition to the petitioner, you need a qualifying relative, and that can be a spouse or a parent who is either a US citizen, and they expanded it to green card holders several years ago. Finally, the waiver's got to get approved, and you have to finish off the consular processing stage, which is with a DS-260, so many forms. That's a visa application to get an immigrant visa. You get that approved with the National Visa Center. You're invited to your interview at an embassy abroad. The US Embassy will interview you, and then you'll get an immigrant visa stamped in your passport within 1.5 years to 2 years of this process. Getting started, you're able to come back into the United States as a permanent resident upon arrival. So that is the quick overview of that process and the timeline. Next question. My parents are Mexican, born there. I was born in the US, and I was wondering if I could apply for dual citizenship And in doing so, could my 2 American-born children also receive dual citizenship? In general, well, this is a international law question, a Mexican law question. We've helped families with similar issues, but as US immigration lawyers, that's our area of expertise. Mexico and the US both allow dual citizenship, but the best thing to do is talk to a Mexican immigration expert to confirm eligibility and the requirements for applying. But it is definitely possible. My kids are dual citizens as well. They are Hungarian citizens and US citizens. And so they have access to the European Union. Dual citizenship is definitely the way to go. Next question. Hello, I'm a Turkish citizen and I'm a green card holder, an LPR, and I live in Tennessee. That's great. We love helping people from all over the world, all over the US. You applied for your I-130 petition in March of 2021 for your wife who lives in Morocco, and she is a Moroccan citizen. My case is at the California Service Center, and it has been actively reviewed since April of last year, 2021, and it's not approved. The processing time for the California Service Center is 24 months. Yes, it's outrageous, isn't it? 2 full years. And because you are a permanent resident, that slows down the process a bit. If you can naturalize, that can help. But you'd like to file a writ of mandamus against USCIS. You're asking, can you file a writ of mandamus within the processing time? And what is pricing, and can you get help from the CIS ombudsman, the USCIS ombudsman? So we love filing mandamus cases, but you have to strike at the right time. And we need to have a judge be willing to agree with us that it's been an unreasonable delay. And unfortunately, if the case is still being processed within their standard processing time, a court generally will agree with USCIS that they are following their procedures. It hasn't been an unreasonable delay yet because all these other cases are also being processed. So what we like to do, and other law firms that do mandamus cases, the gold standard is waiting roughly a year beyond the standard processing time. You could move faster than that, but those are the strongest cases, and we've had full 100% success with all of ours that we've waited a bit longer to make sure that they get approved. So that's our current success rate. And the frustrating thing is that 2 years is a horribly long time to be separated from your wife. And then a mandamus case might require you another full year to make it as strong as possible. So that is disappointing. It's distressing. I wish I had better news for you. And in the meantime, you might want to get some help from a legislator, senator's office, congressional rep to help move your case along. That can help with an expedite, especially if there's a medical reason. Morocco, thankfully, is not subject to horrific violence like many other places in the world that have conflicts or ongoing civil war. So Moroccans are not going to be pushed to the front of the line in that sense, like Afghans, or just given special treatment to move their case faster. But you can always show why the specific circumstances for your wife merit an expedite. And you can ask USCIS to do that. You have to provide evidence that your spouse needs to be moved ahead faster than others who have green card petitioning citizens. You asked also about the USCIS ombudsman. We have not had much good luck with them. We've tried getting their help in a number of cases, and it hasn't been that helpful. They've talked about making their impact more effective, and you can certainly try. It's a free option, but I wouldn't get your hopes up too much with them. And again, you're within standard processing time, unfortunately, for another year. The US immigration system absolutely needs to be reformed. There needs to be significant changes to allow families to be together and to allow fairness to prevail, because many people are not getting fair treatment who are waiting in line, and as they view it, the legal immigration system, as opposed to the necessity of crossing the border, they feel they're treated unfairly. And both are correct. Both sets of immigrants need assistance from our politicians and, of course, from immigration lawyers. It was a pleasure to connect. Let us know if any follow-up questions, and definitely have a good week and take care.